Okay, we're ready to go, everyone. Okay, I'll call the Thursday, May 1st, City Charter Review Committee to order. And with Grace with the please call roll.
Diane Gutierrez,
Present.
Pam Wheel,
Here.
Jonathan Foreman,
Here.
Jeffrey Hank,
Present.
Veronica Wilkerson Johnson,
Present.
Ruben Martinez, Jill Rode,
Here.
Dale Krudoff,
Here.
Lynn Richardson.
Here. Thank you. I knew Ruben has said he's going to miss this meeting and the next, so he wants to be here for a little bit. Moving on to approval of the agenda, is there a motion to approve the agenda as presented? Moved by Wilkerson Johnson, sorry, and by
Order.
Hank. Any changes or amendments to this? Okay, we'll move to the vote. All in favor, say aye. Aye. All opposed, same sign. The agenda is approved. Now on to 1.3, approval of the minutes. I'll move approval of the minutes as presented. There's a second.
Correction.
Well, let's get a second. Then we'll do that. Okay. There's a second for the minutes. Second by Wilkerson Johnson and Mr. Hank.
There's a reference to Foreman. He got it. Yep. It's actually supposed to be me, so I don't have it.
Sure. It's in communications. It references that I shared information on an editorial seen in the Detroit News and an article in the City Pulse. That was actually, yeah, that wasn't me.
Okay, so with that, that's a friendly amendment. I'm sure we'll take that. Are there any other corrections? If not, all those in favor say aye. 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 All those opposed, same sign. The minutes are approved. Now we're on to item 2.1, written communications. You had all those online to be reviewed, and there's quite a few. And we'll move on to 2.2, communications from the audience. Welcome.
Thank you.
Now that you're not incognito anymore, see that smile.
I watch y'all at home and I want to thank you for all the hard work you're doing. Patrick Rose, 310 Oxford Road. Today is Law Day. The American Bar Association tells us Law Day is a national day to celebrate the rule of law, to understand how law and legal process protect our liberty, to seek justice and freedoms that all Americans share. What greater freedom is there than to be protected in your right to live with your own family free of government harassment and a zoning order to break apart your family? So our Law Day question today is, why have a city charter if the city does not follow it? City voters passed overwhelmingly in the 1990s an East Lansing charter amendment that bans family discrimination. And I'll read it. Quote, "The city and its officers shall not, in the exercise of any power granted to or possessed by the city, discriminate against any person on the basis of marital or family status." This is in General Municipal Powers, Section 2, Exercise of Powers. After residents voted to ban family discrimination in zoning and rental housing, the city kept on discriminating against biological and functional families unconstitutionally. Our group asked council to pass a revised ordinance to follow state and federal law and this charter provision to end family discrimination. The city manager promised us all last time I spoke to this committee that he'd follow the Michigan Constitution to implement the recently passed Prop 1 charter amendment. We asked him to follow the 1990s charter amendment ban on family discrimination too. So why is this a problem? Let's dig in. The current city zoning law declares protected biological family and functional families to be illegal occupants when they have a constitutional right to live together. How do we know this? We have two constitutional guideposts. First, the U.S. Supreme Court told us in Moore versus East Cleveland, a 1977 case, you can read it, I've given you the site, that the city zoning law was unconstitutional, which declared two fathers and their two sons and a grandmother to be two families, not one. So the city zoning law ordered the family to break up, threatened them with fines, and the U.S. Supreme Court ruled that zoning law was invalid, defining family to exclude biological relatives not on their short list, which was very close to the East Lansing short list. The court said it violated 14th Amendment due process and equal protection clause rights, and it violated the most fundamental right to raise a family, which is a liberty interest, by treating them all as a single, not as a single family, but as two families. East Lansing zoning law violates the 14th Amendment right to live with your biological family in exactly this way. The city zoning law says a family is two unrelated people or only the following biological relatives: father, mother, biological child, fully adopted child, daughter, grandmother, grandfather, aunt, uncle, niece, nephew. Distant blood relatives are excluded from the city zoning definition of family. It excludes from biological family members first cousins, second cousins, great aunts and uncles, half siblings, and other extended biological relatives, including two sons with their sons being raised by the grandmother. That violates the US Supreme Court decision and more. Each of these families in East Lansing today has a civil rights claim against the city for damages and to enjoin the law, even without being fined. So second, how do we know this is unconstitutional in Michigan? The city zoning law discriminates against families who are non-traditional and qualify under the Michigan Constitution as functional families. We know this when we read the Michigan Supreme Court decision in Delta Township versus Dinolfo, a 1984 case, striking down a law very similar to East Lansing for the identical reasons that we believe East Lansing has to either amend its law or it will be stricken down. Because Dinolfo said, you have a right to live together as a household with a domestic permanent bond, whether you're biological relatives or married, as long as you're not seasonal, temporary, a sorority, a fraternity, a group house, a boarding house. The East Lansing zoning law defies the Michigan Supreme Court ruling in Dinolfo, and I urge every person to read it. You do not have to be a lawyer to understand it. Its language is clear. And it said cities may not have laws like East Lansing that force functional families to break apart by declaring them illegal. They said it's not a proper zoning function. Now let's take examples of what East Lansing today declares to be an illegal family occupant. Blended families, young unmarried couples with a child, couples who foster a child informally but do not adopt him or her or act as an informal guardian under a power of attorney. The city zoning law bans elderly couples who are lifelong friends from living together as a group, say in a 4-bedroom home, defining them as more than one family. And because they share expenses, imposes rental housing fines on them. East Lansing, in fact, has the most restrictive definition of family, the least progressive in the country. Its city zoning law defines a domestic unit so narrowly, it excludes all alternative or functional families, exactly the opposite of what the Supreme Court said is required. It excludes any group of people, that would be all alternate families, any association of persons, any combination of persons, and any coterie, which is defined in the common law as persons living as a household in a cottage. So precisely what the city promises to allow, it excludes categorically. That means no one qualifies as a domestic unit. The city also has no procedure to recognize households as a lawful domestic unit. So alternative family configurations can't even try to qualify to fulfill what the law claims to promise. If they tried, they'd fail, as the zoning law excludes them all. And that's unconstitutional. This is not about keeping students out of single family neighborhoods. Those temporarily living together are not a functional family. They're not protected. They're excluded under our current law. Those provisions would remain when this problem is fixed. Lastly, and we get this question a lot in our group, Prop 1 protects East Lansing residents' right to have live-in guests without those guests being presumed to be a tenant after 30 days and without fear of large fines imposed without warning or notice. It does not change the definition of family to solve the issue of families living together as a family. If you're not sharing costs and expenses and supporting each other, paying the mortgage or sharing household expenses, you are not living as a family. We wish to protect that right because it's the most fundamental right we possess as Americans and as Michigan citizens. So in closing, the city can grant our request, amend the ordinance. If it doesn't, we believe the city manager has the full power to give the written assurance to the city and to everyone who calls that the charter controls over the ordinance, that the Constitution controls over the ordinance. And on Law Day, I ask that we pledge not to break apart families, not to ask them to deport family members who have an absolute right to be there, or the city will face expensive court suits filed by families to protect their most basic right to live together. We are willing as a community group to exhaust every avenue to fix this problem, but the suits will come. And we don't want a single suit to be filed because we don't want a single family to be broken up. Thank you.
I know we changed this, but maybe that language has changed, maybe, or so proposed to change it. Section 2.2 of the charter says, the city and its officers shall not, at the exercise of any power granted to or possessed by the city, discriminate against any person on the basis of marital or family status. Does that language conflict with what I think is happening now? We've added a bunch of I believe we've added a bunch of categories to that, right? But just take a look at family status. That already, like, from a charter committee, if there's something you're asking us to do, is this already protected in the charter and the ordinance is in conflict with the current charter? Or is
That's correct.
it- Okay. So
That's correct.
not a specific ask of like, we can change something here to rectify this.
Correct. Our position is if it's not broke, don't fix it. But all that you're doing on every charter provision is exercise in futility if you stand by and allow the city to plainly ignore a city charter provision, which we believe fairly reflects what state constitutional law requires, and which the voters passed in the face of an ordinance that was being used unconstitutionally to take away their rights. So our ask is that you use your power as citizens, because you believe in the charter, to see the charter enforced according to law, according to its own terms, according to the state constitutional requirement, which it's not allowed to conflict with, which we think it codifies, and with federal law. With your support, with the support of the Housing Commission, the Planning Commission, the Age-Friendly Commission, and what we think is the vast majority of people, we think it'll be in the high 80s if it were ever put to a vote. It's not going to be put to a vote. You don't vote on rights you already have. You go to court to get them enforced. We think the city will want to enforce the law in the way that they're required to do and not strip out people's rights, which we think they're now doing.
Your problem. Just pulled it up and looked at it. Yeah, it doesn't say anything about families in here, but I saw someone online commenting on an article about what the city council or housing commission are doing with this. And they were saying something essentially like, didn't the charter amendment fix this? I think you kind of answered that. But could you just help me understand that a little bit? Does this, the charter amendment that recently passed in the Fed, but I'm not talking about 2.2, this is 2.1, does not prevent paying tenants. So these familial situations where people potentially consider tenants, they share costs and things like that. Is that what you're saying? That
Yes.
the top one didn't fix this either?
Right. We did one half of the problem. We fixed the part of the problem where you have a family member, let's say a great aunt, and she's just living there and not paying rent, not sharing utilities, not sharing the mortgage payment. We gave her a right to live in your home as a guest. We gave her a right to have 7 days notice. We gave her a right not to have retroactive fines. So you're safe with your great aunt. The problem is we met about 28 different sets of family circumstances. There's more than one group of families in each of these categories, but I'll give you one example. The great aunt who's living in the family to care for her grandniece who's sick. And she's there to provide childcare and support with her Social Security check. The city defines that as rent. We didn't protect against rent paying tenants, but being a family member who is holding on to that protection that the Supreme Court gave her, she's a constitutional family rights holder. She can hug the bundle of rights. She can carry them to a judge. A judge will hand her that right. And that will happen either a threat of fine or a threat of eviction, because the people we spoke to had read the law, knew they were violating it, and that gives them a right to sue. We don't want people to be under threat. Many families have broken up and self-deported, where they have a constitutional family member who moves out in fear of their rights, in fear of fines.
When you use the word deported, you're not talking about like federal deportation. You're saying someone's leaving the city. Or are you?
They leave the home because the zoning power that the city pretends to possess evicts them under threat of $250 a day fines. They are deported out of their own home unconstitutionally. And we want to stop breaking apart families and self-deportations. We want to protect the city's budget against those lawsuits because they have been brought, they have won, and the city doesn't need to face that when it's violating its own core values by taking that risk. We all support families and we all support strong neighborhoods. And we just simply have to get around finishing this last mile in protecting people's right to live in their own home.
Do you have any indication in the 7 months since the charter amendment passed that there has been any enforcement action by the city?
So we have been FOIAing each of the fines. We will continue to do that. We've communicated with some of the people who are fined. We will continue to do that. The harm I'm talking about exists even without fines being issued. And we have been in communication with the families we identified, and we made a promise to them we would fix this problem. As a taxpayer, I want to fix the problem without any suits being filed.
So I'm sorry, if you could just answer. In the last 7 months, has there's been enforcement? You understand that you believe conflicts with the amendment that was passed?
It's impossible to answer because answers are being given at the desk. We have evidence of this, that people are being told what the law is, the unconstitutional version. We believe people understand what they're told and follow it. And we believe people are limiting their life opportunities by following an unconstitutional law. They're not being told that the city's prohibited from enforcing this narrow family definition. That's what we asked the city manager to do, to give written assurances to the public and to make sure everybody at the desk is not telling people the unconstitutional language in the ordinance. Now, we have heard that the ordinance should be enforced as written from city council members, from the city manager, and we believe that staff are enforcing the unconstitutional language. That is what has caused the harm in these last 7 months. We know who these people are, and we know their rights are violated. We're holding off because we want the city to fix it. Did I answer your question?
I think in a way, yes.
Okay.
What are you requesting of us?
We're requesting that you read our proposed amendment that defines family in the letter that we gave to council, the planning commission, the age-friendly commission, and urge your city council members to adopt it and speak to your city manager and ask him to instruct the rental housing inspector, the city attorney, and the zoning officials to enforce the zoning ordinance in a way that conflicts with the charter, because you're the charter review commission.
We're
And
just review commission.
we assume that I made an assumption coming here that you wouldn't be here if you didn't think the charter should be enforced and that you don't think the charter is a dead letter. Louis Brandeis said, the citizen is the highest political office. So I would say you have the highest political office.
Can you state again the name of your group and exactly what is your role? Is you're mentioning that people are being affected. How do you know about this? Do they come to your group and ask for your intervention, or how are you?
So we are a group of people who oppose family discrimination, but we can't give ourselves a name because many of us started out in support of a ballot proposal, which was on the ballot as Prop 1, and we have a ballot committee. However, we live in the neighborhoods with people who disagreed with us on Prop 1. We have not found anyone who disagrees with us about family discrimination. And many of the people who voted no on Prop 1 have joined us to oppose family discrimination. So right now we're calling ourselves a community group against family discrimination. And we're following the budget very carefully because we've seen 2 major lawsuits, the Apple Farmer suit with an $835,000 liability for violating free speech constitutional rights. We don't want to see that happen again. And the unconstitutional franchise tax, $1.4 million. The County of Ingham just got hit with a $739,000 judgment for violating free speech and religious liberty rights. We think we're smarter than that. We're stronger than that. And we're smarter than that. And so We don't have a formal name because if you said we're Prop 1 ballot committee, that's not fair. It's the people we talked to who agreed with us and the people we talked to even who didn't agree on the Prop 1, but absolutely agree on this.
I think you didn't answer the second part of
Yeah,
Ron's
the
question.
second part was how do you interact with them? How do they know? to
So-
come to you personally or to-
So we had about 84 people who went door to door. We went to 8,500 homes off campus twice. We went to 5,400 student housing twice. We spoke to people when we did our poll on our language and learned their circumstances and kept detailed records. People mailed the ballot to us. We got signatures. We collected signatures. We were all over the city talking to every neighborhood and festivals and all over the university. And then we campaigned door to door once we were on the ballot. That's how we collected this knowledge. And we made a promise to fix the family definition so that there's no discrimination, because Tony Chubb and Carrie Singh said we should take out the definition of family, and we agreed because it's already in the state constitution and we didn't need to define family. But we said we will come back and take care of this, and we felt we couldn't abandon those people.
Summarize, this is that council and housing commission now, and the ask of them is to just comply.
Use our language. We gave language. We have a committee of lawyers. We drafted language. We could not get a hearing on our language in the planning commission or in the housing commission. We asked council to look at it. We think council will look at it. And we're asking our language to be the subject of citizen lobbying.
If the charter says you can't discriminate on family status, families defined a certain way under federal or state law, then East Lansing's ordinances need to apply to that, correct?
Yes, they have to be changed.
You have a city attorney, a city manager, and a city council member here. I'm curious what they say about this. Or is it not an issue or not an issue? What's the status of?
I've spoken to each one of the council members, and I'm anxious to learn that myself. I have heard Tony Chubb say that it doesn't violate more, and that biological family members are as extensive in Michigan's East Lansing definition as more required. And I went back on March 26th to the Planning Commission to explain exactly why no reasonable lawyer could give that opinion, because cousins are named in the opinion and biological relatives that are included are obviously not on the list. So the opinion he gave doesn't match up with what a reasonable person or lawyer would say. That's why we offered opinions. We have 9 lawyers active in our group. We offered to come and answer questions. We gave a formal legal opinion at the last council meeting. We don't think you'll find a judge or a lawyer who will agree with Tony Chubb's view that we are in conformity with the requirements of Moore because of how we restrict biological relatives. And he gave no answer to Michigan's requirement alternate families be allowed. We showed that they are not allowed, and he didn't answer any of our points. So we don't have a legal opinion that will protect the city, and the city hasn't gotten an independent legal opinion, and it hasn't let a retired judge testify, a state magistrate, the 3 lawyers who've done municipal law, the former county prosecutor, the lawyer who was formerly chair of the school board, Stanford Law. None of those lawyers were allowed to come and answer questions. And so I am in fear that the city's getting bad legal advice. And it's one of those situations where pay me now or pay me later, and we don't want to have to pay ever. We just want to follow the law. That's why I'm here on Law Day.
Thanks, Patrick. And I just, I want to be kind of clear in what you're saying. You're bringing it to our attention that somewhere in the city, people are not following the state definition of family, and it's going to cost the city because these people are being told they can't. They're being discriminated based on family. Nobody's been fined since Prop 1 has been.
That's not true. We have a long list of lawsuits where people were fined and their rights were vindicated, and this goes back over 28 years. And we have
She said since Prop 1 passed.
oh, I'm sorry. Yes, we don't have evidence of that happening.
And our proposed charter amendment is broadening anti-discrimination possibilities so that that's covered, but we've kept family status as family status, which would revert to the state and the federal definition. So we as a charter commission have committed to what you're saying.
Yes,
It's in the hands of who, takes and implements that. And so when we pass on our charter amendment, recommendations that we've all decided on at the end of maybe June, we're there. We'll take under consideration what you said in our statement to council to, recognize the people that have come before us and what their concerns are.
okay. And I can't because I was hopeful that you as Charter Review Committee members in your role as citizens would be the most friendly and the most likely audience to help us fix the problem. So I'm really making a plea to each one of you individually.
Something else we've done, Jeff, correct me if I'm wrong, is we've made it so that passing a citizen proposed ordinance would be easier to implement. So, right now, the way the charter currently stands, it's easier to pass it's easier to get a citizen approved charter amendment passed than an ordinance. And we have made recommendations, we'll be making recommendations to council to make that process easier as well, so that if you feel you're not getting your audience from council, which it sounds like you're not, you could also bring your audience to the citizens of East Lansing, which
We can't do that because there is a confused body of law about the power to initiate an ordinance to change zoning. Yes, this is unconstitutional zoning. So
We're getting into corrections.
yes, yes.
The chair articulated, aren't we at this juncture, we've covered verbiage that protects families. So what we're talking about is enforcement of written rules that are acceptable. So between Prop 1 and the articulation of family, that's all, the written part is all set. Now it's a question of enforcement.
Well, yes and no, and here's why. We're 6 months out from Prop 1 and we don't have conforming ordinance language. So people who read our ordinances are reading illegal and unconstitutional ordinances because they conflict with the Prop 1. You don't have a provision in your charter that requires timely amendment of ordinances. When you don't timely amend your ordinances, which you have not on Prop 1, you're 6 months, 7 months late, and you have not on the family definition, you are 28 plus years late, courts will rewrite your ordinances. Why not have a provision like other cities do to require that the ordinances be amended in a timely way to implement the charter? And we're trying our very best to prevent having a judge rewrite the ordinances because we trust our community and we trust our council to rewrite them, but that's not happening. So maybe you need a charter amendment that requires quicker, more timely action to have conflicting ordinances amended because the charter is the supreme law. It's the constitution of the city. And to have those ordinances hanging out there while the council dilly-dallies should be unacceptable to a charter review committee.
That sounds pretty reasonable. You want the city attorney to know. What do other city charters say? Like, what's a reasonable amount of time to enforce the ordinance after that? I mean, obviously, like, there should be invalid the moment that becomes effective.
They are invalid, but
Right,
you
but-
require a law degree to know. So that's.
Yes, it should be formally fixed. Is there any guidance by, what other charters committees do?
So, sir, are you saying when, and I know it's not specific to this, but are you saying that is, because the city does have, and I'm sure you're aware, there's a section, because it doesn't always get codified right away. And there's a section on the website and it'll say, these are our new changes. Because I think Robert, correct me if I'm wrong, it's probably maybe, I don't know how often do we actually change them physically. Because I think there's a cost to change them, putting them.
They're submitted, I think, too.
No.
The mini code, or, yeah.
You may tell me.
So are you saying, so the concerns that you're having about ordinances not getting changed, they're not even put in the hopper, I guess, if you will, at the top part? Do you know what I'm talking about on the website?
So what I'm saying is that legislative action is required. The council has to take up and pass amended ordinances that conform to the changes. Absent that legislative action, there's a conflict, and that creates confusion. People who look to the ordinances and read only those ordinances and are not given a cross-reference to the charter provision that shows it's no longer valid with an explanation cannot know what their rights are. So then they're told something based on ordinances. We have good evidence the city is still doing that. And their charter rights and state constitutional rights are being violated. So we are going to ask the city manager to fix that, with a written assurance that the charter controls and an explanation and a clear directive to staff. Absent that, a court will not wait to rewrite the ordinances, and that's the last thing a city should want. So if the city wants to be well governed, it should set a very specific mandate on its council to give priority to the amendments to the ordinances to ensure that the charter is implemented. That means getting rid of conflicting ordinances.
I think the question specifically though was if there's a change in the ordinance, is the ordinance immediately implemented? Is that? 'Cause I think that
Yes.
was-
It's,
So I know, I understand what you're saying and that's the bigger picture, right? But I think the more specific question was that is it put into action right away or what that grace period is? Is that what your question
So
was?
what I heard, what I thought made sense was maybe we ought to have a provision in the charter.
Right.
It says if the charter changes and that requires ordinances to conform, that does happen sometime.
But the ordinances.
Yeah, not that it's left, and it shouldn't take 4 years.
Right.
Maybe it's, needs to be some amount of time, reasonable time to do it, but that's up. There are other examples that you mentioned, maybe there's other communities, like, I don't know.
there are.
So if we just get like for the next meeting, like proposed, maybe thought this makes sense, like a proposed just generic language on what's a good practice for conforming with the charter.
Or any kind of law change.
Yeah. Yeah.
So if a law changes and our ordinances aren't conflicting,
Yep.
we amend the ordinances within 3 months, or whatever.
Like it should be brought to council's attention, I would think,
Correct.
right away. and
Okay, and so then the final,
Do we have a current sense of how long it is taking?
Yeah, I can tell you exactly how long it's taken. We began the process before proposal one was passed to bring all the rental housing pieces into a single chapter of the ordinances, sent it to the housing commission. Housing commission took a look at it. Proposal one passed. There were changes made to the ordinance to conform to proposal one. And then that was referred back to the housing commission. Housing commission looked at it actually for, I want to say, at least 2 meetings, so that's 2 months. Then they recommended changes. We introduced those changes. It was actually on the agenda, I think, 2 weeks ago, but we deferred it because we were introducing, because we peeled out a lot of language out of chapter 6, because this part of the problem with the rental housing provisions was some were located in chapter 6, some were located in chapter 10. We wanted them all in one spot. But the chapter 6 changes were introduced that night, and we wanted to pass the rental housing stuff and the proposal 6 changes at the same time, so that there was no break in enforcement. So that was the delay. It has taken a long time, longer than I expected, frankly. But it's not because people weren't working on it constantly.
okay, and so the one last thing that I got from your statements was that there are people on staff that are giving the wrong information to people because. So could you get with Mr. Bellman at some point in time and give him the names? You said you have clear evidence, so he knows who to have a conversation with to see if they're following what it's supposed to be following.
The attorney who's representing that family is going to communicate with the city manager. We're meeting with him Wednesday at noon next week. And we really are asking to have an opportunity to present to the housing inspectors, Elsie Hodges and her staff, because without that, it's impossible for them to understand our position. And it's very important they understand our position. If they are continuing to act in a way that violates the state constitution, they're putting us all at risk. And I'm a taxpayer too. That's really what we're looking for. We're not asking to do it in the absence of the city attorney. We're not asking for anyone to agree with us. We're just telling us what we think every judge we're in front of ever is going to see as the law. We have no way to have that conversation. We've been frozen out of how the domestic unit status is done. It took me 18 months to get an answer on that. And so we think sooner rather than later, July, pretty much the outer marker, the city's going to run out of ice. Thank you.
As a council member, makes sense. up to you to have something like that in the charter that says the council asks, get to work in some reasonable time to conform ordinances when there's a law change, or is that?
I don't think it, I think we do that personally. But I will also say that, when proposal one passed, as far as I'm informed anyway, we conformed immediately to any change that was necessary because of proposal one. One thing that it's important to remember that there were a number of changes that were required by proposal one. So to the extent, I can't remember, I think it's number 4, you've got it in front of you. Indicate, is that the 7-day notice provision?
Yeah.
Yeah. Can you read that? It's just real quick.
For zoning occupancy or rental housing laws, the city must first notify owners and occupants of the violation by issuing an order allowing it to 7 days to comply with the law.
So we requested right away, ordinance changes for the 2 provisions in the zoning ordinance that, provide for a violation so that the 7-day notice could be included in there. We haven't got those bills yet. We haven't got changes to that yet. We also started to ask for changes to, and I think we do have one ordinance that's pending to make changes on the, that was in the rental housing provision, not in the zoning code, because the 7-day notices have to be included also in the limitation and any changes there. So those are pending still. But as a matter of process, everybody's getting a 7-day notice at this point in time. Nobody's being told you got to have that done tomorrow. They're being told that at least 7 days, out. And to the best of my knowledge, we haven't had anybody who defaulted on any change that was ordered. So I don't think we've had any fines that even we had to deal with retroactivity on. People tend to comply with the notices once they are provided them. So those are the only 2 things that are pending, other than the combination of the rental housing code from chapter 6 and 10 into chapter 7, where will all sit at one time.
There was a law change regarding water. You guys would amend that ordinance as soon as possible after that law change,
We would do all that all the time.
just regular.
Right,
just
as a regular.
Standard operating procedure, you would amend those ordinances
Absolutely.
immediately.
Yep. Yeah, but the simple fact is, even without a change to the ordinance, we can't, we have to
I
comply with the
understand.
charter.
I understand.
So I think I would be astonished if the city manager hadn't already instructed all staff, this is how this has to be post proposal one. I'd be astonished that they were telling anybody anything different than anything that is in proposal one. And I don't think there's any evidence that that is.
So a couple of things. First of all, I'll be interested in seeing the convincing evidence this group has of staff providing misinformation regarding Prop 1. Secondly, we have been at this for, I don't know how many months now, and with 4 attorneys sitting at this table. Okay, how many times have we read charter provisions and tried to figure out what they say, right? And what they mean? Prop 1 is no different. It has taken us time to ensure that what it is saying, we're trying to reflect in our ordinances. So council has done what they've always done, and that is they give a first reading, they send it back to the boards and commissions that are experts in this area to get us feedback, to get more public input, to ensure that we're conforming with the intent of that charter provision. So the process is taking a little bit. We can circumvent that public, input from our boards and commission. But I think we value that here in East Lansing. And so it's not like we're intending and ignoring Prop 1. We want to make sure the adopted ordinance is right, doesn't create more confusion, provide more misinformation. So it's a little longer process. But I think we've experienced it in these meetings, trying to understand what was meant when it was written. Because nothing is as clear as the language that's up there. Because when we try to apply examples, situations to it, we stand back and we say, well, what does that really mean? And so that's what's happening with what will become chapter 7 in rental regulations. But then we ran into, as Mark said, a timing issue when chapter 6 still contained rental regulations. We were on the second reading of chapter 7. We didn't want to adopt one without the other because then we have 2 chapters that conflict. And so we held off on the one to get the other one to catch up. And we're going to make it as a single motion that both the ordinance amendments will be adopted simultaneously. So we'll remove all rental regulations out of chapter 6 and we'll adopt chapter 7 with the new rental regulations that conform with those provisions of Prop 1 that we were required to conform with. So the only other exception is that 7-day notice is the baseline. If there's a health and safety issue, state law will trump it. We have immediate right to address and aren't required to give 7-day notice. So that's some of the stuff that, gets looked at, make sure we're doing it right and continue to, we'll sit down, we'll talk, we'll write up language, we'll take it back, we'll review it to make sure it's capturing everything that we think it needs to capture so that a resident reading it, staff reading it, fully understands and appreciates what the intent is and trying to conform with the charter requirement. So thank you.
Can I say one thing to thank the city?
Just to be clear, every time you're talking about chapters, you're talking about chapters in the zoning, not chapters in our charter.
Right, chapters in the ordinance.
Okay.
Just zoning.
That's not-
I said one thing. So, I mean, Michigan still has a law in the book that conflicts with Florida in Texas, right? I'm sure, that hasn't been dealt with for the last 22 years. People who are affected by that know that the state can't enforce that law. Prop 3 passed in 2022. The legislature did a good job, I think, over the last couple of years trying to fix issues where Prop 3 needed, or where the amendment that was passed in Prop 3 needed to be enforced. They probably missed some. People know that those laws can't be enforced against them. Your group knows what the law is, knows what the charter says. It doesn't, and the charter is not dead letter, just because there's some delay in passing ordinances. So to the extent that what you're telling us is that it's our obligation to make sure the charter is not futile, we are doing that. The charter remains not futile so long as there are people who are the people who are being presented with the information are able to advise citizens that this is what they are and are not allowed to do. And so you're telling us that people are coming to you to your group to ask questions. You know what the law is. So you should tell them this is what the law is, this is what the charter says, regardless of what any ordinances say contrary to it. And so I think we should leave it there.
I really appreciate that comment, and I do want to thank the city manager. We came to something I didn't come to speak about. I didn't say a word about Prop 1 not being implemented quickly enough, and I have only praised the city manager for what he's done on Prop 1 to implement it. And we've said to everyone who asks us that we trust him to implement it, and we think he is. I came to speak about the family definition, and we have all the evidence we need to know that the city has been enforcing that illegally and unconstitutionally. Mark Meadows told the Housing Commission and the Planning Commission that you can ban cousins. He flipped and said first cousins now should be allowed, but he said to the Planning Commission, you can ban second cousins. That is plainly unconstitutional. So the only issue I came to talk about is that 28 years later is too long to change the ordinance to comply with the 1990s charter amendment, which the city is flagrantly violating. Eric Altman said repeatedly, and I think it was 8 times, that any alternate family can be certified as a domestic unit. We've established that's not true from the language and from the practice. So we know from our discussions that people are being threatened with our taxpayer dollars for the violation of their rights. And to your point, and it's a good one, the sodomy laws prevented felonies for people who commit sodomy after Bowers v. Hardwick, and it prevented giving a woman a felony for seeking an abortion. I was a lawyer for the American College of Obstetrics and Gynecology. I was part of going into states that violated that and gave women felonies. They paid huge damages. They were enjoined immediately, and they were forced to stop. East Lansing is showing, unlike almost every city in every state, that when the US Supreme Court speaks and makes sodomy legal, a constitutional right, and bodily autonomy legal, a constitutional right, the city isn't willing to follow or listen to the Supreme Court. And we're here because that's happening with enforcement staff. They tell you who you can live with, and they tell you face fines if you can't. And they're told that at the desk, they're told that on the website, they're told that when they read the ordinances. That violates their rights.
All right, thank you, Patrick.
Thank you.
Just let me say one thing, that if you want to look at an old housing commission meeting, which I'm sure was filmed in some way, you'll see what I actually said about cousins at the housing commission, which is not what was just represented.
Okay, we're not gonna
Thank
be
you.
here to argue between what
Thank
was
you.
said and what wasn't said.
Thank you.
All right. Okay, there's no other people in the audience, so we'll move on to communications from committee members. And I will just follow up with, we had sent a letter to Mr. Hollister, inviting him to come to our meeting, and he responded to Ruben saying that he's currently involved in promoting some training right now, and he might not be able to present at the meeting, but he did pass on to Ruben a draft of the preamble that he presented to the Lansing Charter Committee, along with the proposed amendment that would require the mayor to submit 3-year strategic plans. And I just said to Ruben, when he gets back, it would be good for him to send that out to us ahead of time. And when he's here at the meeting, then we can talk about it, because we'll still be on the preamble like by the time. But he's missing one more meeting at the next meeting. And it'll be, if we solve the preamble by that time, we could look at what was there and see if we, see if there was anything we wanted to change. And if we didn't, we have something else there. So that's the plan for Mr. Hollister. So anybody else have any questions? Pam?
Yeah, so I sent a communication because quite an emphatic citizen was concerned about confusion about the role of the mayor. And I assured him, because I've dealt with that confusion myself, that the charter is quite explicit about it being an equal vote situation, and that the mayor is identified as the chair per other laws. Like if you need one, that's the mayor. So I assured him I'd look into it because he thought there was more. They thought there was more. And the only other place there's the mayor signs something. So in our charter and in our ordinances, there isn't anything else except for the emergency manager, which is the city manager. And then it's a language issue. But after Mark's response, I started searching some more places. Well, the Home Rule Cities Act requires a city to, it's mandatory that each city, the election of a mayor who shall be chief executive officer. So that's where chief executive officer comes from. That's where the language comes from. I don't think it's helpful in terms of being kind of confusing about the role of the manager, but I don't think that's the charter's beeswax. Clearly, we are required to say chief executive officer for the mayor by the Home Rule Cities Act. So, and I do think it behooves the council people as well as city, as all of us when we see it, to say, the mayor doesn't have any extra power.
Mayor does only have the power to call the National Guard.
Right.
So, or to perform weddings.
So, oh, really? I didn't see that. But yeah, so I just think that's something that the process is gonna have to re-articulate. People will be reminded. You may be talking to Mark like I keep thinking Mark's the mayor, like he's the mayor, but he won't be able to give you anything. Because that's, so yeah, so my communication is for it.
Well, following the Trump theory, I could issue executive orders, it would be illegal.
Yeah, that's a rule of law. What?
Please don't go there, okay?
That's a whole new, but anyways, typically, yes, in cities, chief executive officer is your highest elected official. City managers are known as chief administrative officers.
Except in Grand Rapids. And the description, when it came out of business, because I came out of business, IT with chief, well, university, but chief officers, whatever, it is, they report to a board. So traditionally in a corporate setting, your chief executive officer is the head of all the staff and reports to a board. So it really is more of a city manager in the business sector. It really does describe more of a bit city manager role. Where you report and are hired, fired by board.
Right.
And, yes. But
Government likes,
it's in the Home Rule Cities Act, so we gotta do it.
You don't say.
Mark, you could issue some orders to enact some tariffs to solve the city's financial problems.
he's trying.
That seems to be like a loser.
I'm sorry, I should, I said don't go there. Yes.
All right. Anything else, communications from the committee members? All right, we're going on to new business 3. We're on to chapter 18, alcoholic beverages. And I hope everyone read through this. And I just want to clarify, to make sure, I have some questions on this, so I'm just gonna start it off. On B, we have no restaurants less than 50 people that have, that are allowed to serve alcohol. I mean, that one's sort of stood out to me.
Yeah, I'm trying to.
We talked
Okay.
about wine bars at one
Someone
point
gets
in
the
time. We
background
talked
on
about.
This goes all the way back to 1972 or whenever it was that we went wet. And you have to remember that we required 50-50 rule. So it was only restaurants that were licensed, and we defined restaurants as having at least 50 seats. So anybody who had less than that didn't get a license under those circumstances. Personally, I think this particular section has a lot of problems. And probably we should look at narrowing it significantly. Some of this stuff doesn't even apply anymore. We've gotten rid of the 50-50 rule. We have a whole, we're not going backwards here at some point. So a lot of this language was really all about the fact that we went wet. At some point we had been dry before.
Can the city manager talk us through how liquor licensing works? I don't know, or if Robert, you know.
Well, liquor licensing is all handled by the state.
It's by handle by the state, right? So can the city do anything about it? If liquor license, if a building or if a restaurant under 50 seats had a liquor license,
So
I would think that'd be preempted from the city being able to do anything about it anyway, right?
right, with the exception that if you want to open a liquor establishment, be a restaurant, it's under a special use permit. So zoning is going to control that, which comes from council. So, but the liquor license comes from the state. It's whether you can operate that business in the city, in the zone, in the building that you are, and then council reviews that after planning commission.
So I guess my question, could the city, if a business had a valid liquor license from the state, could the city enforce this law in
You
any
can't
way?
get a liquor license unless you're in the 50.
We can only make a complaint.
Right.
So,
The city says you can't open a bar here, you can't get liquor license.
right, but I'm maybe not explaining myself well, or maybe I'm just not understanding the process well enough.
The state is going to trump all of this.
Yeah, okay.
Yeah.
So is there a point to this
Yeah,
in any way?
this chapter at all, is it?
That's it.
relevant?
Quite question for the city attorney to review and then advise whether state law trumps all of this, and whether this provision should be recommended.
There is one more point, there is regulation in the city can do with alcohol, and that's just done by ordinance. Locked in here.
Right.
Okay, so it sounds like that's what we're gonna ask you to do. I have if you have some other questions, anyone has other questions too, just bring them up, but we have these instances where I'll use the library as an example. The library has their books, bites and bids. I didn't go this year, so I don't know if they did this. But the Friends would apply for a permit so that alcohol could be served there. That doesn't kind of fall in here, but probably we should have something. And we don't allow alcohol in the parks, but we know alcohol is in the parks.
We did allow alcohol in the park.
That's ordinance open alcohol in any public places.
Yeah, we
by
could,
ordinance here.
we have the ability to do that.
Yeah.
But, I mean, the 18 could be changed to just take out the on. So instead of it shall be unlawful, it shall be lawful for any person directly or indirectly. Or, you know, I mean, you can change the nature of this so that we put into the charter that we're no longer dry. Let me put it that way. And that's all you need to say, because state law basically controls everything else.
Well, but zoning, once again, we can say the discussion around
We have-
gas station liquor laws, right? It just doesn't maybe belong here.
Right.
Saying, it's not saying we're not gonna have any control of it.
Okay, so and then a couple things in this, because when I was reading this, I'm remembering all these things that came before council. So we have the place that's manufacturing alcohol in, the old Public Works building on,
Red City
Right.
Spirits.
Right.
Yeah.
and so wanting to make sure when you talk about this, it says the manufacturer consumption on private premises, that's a private premises. You know, that kind of seems, I would think that seems to be in there because that addresses that business. This is on F, because we have, and so we had to go through, they had to go through a lot of, review because of what was there. And then the druggist with pharmacy, I know you guys probably don't know that, but alcohol used to be given as a drug to stop labor. And so, they were dispensing that. So I know that that's coming from
You already thought is the alcohol.
No, that was an old way of stopping labor. And it was a fun patient to take care of. And then we also talked, I just somewhere in here how, if you have an event in the city, so that's, you know, it's an event on city property, whether it was a library or at Hannah at different times, and the people apply for permits, how do we write that in here so that it's clear? Because someone sees, oh man, the library had alcohol at their event, and we used to have it at the Crystal Awards too. How did they get it, you know? And you always had to apply for this special use. It wasn't a special
It's
use.
just a permission for that. And we get it for patriarch or
Yeah,
family reunions. They just
That's what-
get
yes.
authorization by the city manager. That you can make it.
so I think we need to put that in here so that, because otherwise there's a conflict. Someone sees people having a family reunion with alcohol there and someone thinks that all of us can have alcohol there, but it says park.
Is that in the ordinance?
I would think that'd be in the.
So we might reference an ordinance, say, special ordinance or special.
Or the city shall provide an ordinance that guides
Okay,
where alcohol can be consumed on city property.
okay. And then, like you said, it's lawful instead of unlawful. And we don't have the 50 diners anymore, or the 50 beds even.
But where it says, here, as defined by the Michigan Liquor Control Act, we have the except as follows. I think you could eliminate all that and just provide that it shall be lawful. You know, basically in accordance with the Michigan Liquor Control Act, which also provides for these temporary permits that we could apply. I don't know that we need to actually identify those as one of the things that can be done. As long as we just make reference to the state law that governs just about anything that we do regarding this.
But I like a state law, but I like that you say somewhere in here, because there's mixed messages out there when you see people with alcohol in part, you know, they're bringing it and then somebody else thinks they can do it. I think the charter just, who knows to go to the ordinance unless you say that the ordinance provides that in the charter.
Do we put up signs there? Do we have signs?
No, and it used to be back in the, when I played baseball, it was like 20 years ago, we could have beer patron. And that was just, everybody brought beer to the baseball games.
If you're on a date, you have a picnic, and you bring wine, you can't do that?
You can't have open alcohol in public space.
So you need to chug it as quickly as.
It's the same as students walking the streets with open beer.
It's not the same as that.
It is the same.
But you raise a good point. Should that be
Public streets, we don't allow
allowed?
That's just so.
Well, and that would be, because that's currently, that's not allowed in the ordinance, that would be due. So for this, do we, and Diane will write, do we want to say lawful and just kind of cut out the rest of, say Michigan liquor control and then say something like, and to reference the city ordinances as well? Because that talks about
Yes, I
permits or, okay.
And I don't think anyone cares about the drugs premises giving alcohol.
My question is, anymore, do you need this chapter at all? Is this entirely historical?
Right.
The city has the power to regulate alcohol in ordinance. You don't have to worry about listing various things in the charter.
So you-
Current, like, for example, in Lansing, is their new charter gonna have an alcohol chapter? Or is that just historic? And it's kind of archaic at this point. That is the question.
So do you put on the ballot, we're eliminating this chapter, and the references because city ordinance will, city ordinance and state law will, govern this.
I just say, if it's not
But you have to have
necessary,
a-
it's necessary for the city to actually have powers to regulate alcohol, you can just do it by ordinance, not blocking anything in the charter.
And honestly, I like that idea, and I like the voters having an opportunity to look at it, because I would love us to stay with 50-50. I think the cost of the bar scene we have is exorbitant. And so I would like to see a reminder coming from voters that we could do something about alcohol. Just, I think we should be reminded that.
I would suggest that we get from the city attorney some indication as to whether we can eliminate this and just rely on ordinances, because, there's kind of a complicated, night when we repealed the ban on alcohol at the national level, then it was left up to each state, and each state put into their constitution as to a process for local units.
Is that,
For local units to go wet, and we never went wet, so it seems like we probably complied with whatever the process was by putting it into our charter. Just want to make sure that we don't have to also have something like this in the charter.
But even that opening paragraph, you read that, that sounds like we're talking about city employees. Or naming them clerks, agents, and the same things we've called them throughout the whole thing.
right, as if the city.
So, yeah, so that has to be fixed as part of this, because it looks like the police chief can't be
Yeah, still on behind.
taken.
There probably was a lot of drinking in the clerk's office.
Only during a selection.
All right, let's go into chapter 19. We've got a plan. City liability. And, there's either whether you have it on the street or off the street building. And it's very detailed legalese. And my guess was when this was amended in 97, Mr. Meadows, that, this explicit language was set there so that you knew if you had a complaint against the city, if you were injured, you had to follow these rules. It's not in an ordinance, right? It's in our charter.
Yes. And this would, at least as of 1997, have followed whatever the state process was for notification.
So in this chapter, I did email it out to MMRMA, our being risk provider, to take a look at it to see if there's any recommended language change they would have, and I bring it back to the charter review committee. At least consider it.
The governmental immunity statute is reflected in this language. That's why this language went in the charter in 1997. I can't remember the year that we passed the governmental immunity statute, but it wasn't that long before that.
So as somebody had this come before them on council many times, that government immunity statute is not referenced here at all?
No.
And when you have flooding in your basement, everybody right away believes that if the city didn't do something, that they have the right to get some reimbursement, but that's covered under the government immunity statute. So do we need to have something in here that references that? This is just a personal injury. Seems like that you're covering in this, but you're not talking about your property.
The city has provided funds.
Well, the other comment I would have is that The governmental immunity statute trumps all this. You know,
Well,
if there are changes to that, that conflict with this, it's the governmental immunity statute.
but should
So
we reference
we need
this?
this in the charter, is the real question.
And do we just say city liability and say the government immunity statute covers what the city can do versus listing this out?
And that would be like a question for the city attorney.
That's a question on that too. So I don't know what Mark just said, is this necessary to have in here or not, but I read 19.1, it reads that like if you're injured and you have a claim against the city, you have to give the city notice within 60 days. Here's, does that actually happen? And is that enforceable? Because I would think that people have statute.
When there's a, and Ann can correct me, when someone trips or gets injured on the sidewalk, they have a very limited time frame to notice the city. I don't know if it's 30 or 60 days. They don't do it in that time frame under state law, they cannot sue.
That's essentially what I'm asking. Is it 60 days in here? Is that?
That's why I said I'll send them an RMA to look at.
Okay, yeah. I guess you just match with our own thing. Like laws. I don't know.
Okay, so the idea that we will potentially, if it's okay, or we would just say to have it reflect the government community statute. I think that would probably be least confusing.
Well, and it would be in the sense that people that are in this office or on city council at the time when something like that happens, it's very, well, I know on the third point, 19.3, some members of staff promised something and then it wasn't really what they could promise, and that kind of covered that doesn't, you say it doesn't mean you're not actually gonna get it. It's the government immunity says this is what we do. And I think people are really frustrated, but it's not the city that's making that decision. It's the government immunity statute. And so that's the guideline.
And case law, I might add about 3. There is case law that says that you have to have actual authority for a government to have commit something. So city council has to act in order to say agree to a settlement of some kind, even though our attorney, might have said, yeah, this sounds good, we're going to do this. And there have been cases where things like that have happened and then somebody sues to enforce the supposed settlement. That's why this language is in here, to let people know, you've got to have actual authority to make this happen.
Yeah, so I'm sort of concerned that should keep in here because that puts the other people. And has some work to do, chapter 20. I know Jeff Hank was talking about this in a quick thing about the table of contents and having the right page number. If we talk about chapter and section headings, wouldn't that be covered under this? That really isn't part of the charter. It's just going to be perfunctory, and we'll make sure when we go through this, that it's appropriate.
I was kind of got laughed today that anyone else noticed this, moving to that, like, wait, the page number's wrong.
Yeah, it's out with negotiations at the end.
Are these 1, 2, 3, 4, 5, and 6? Is that weirdly
No,
heading to, or is that supposed to be that way?
no, I think that amendments is all about when it was first put out. And that's the schedule of how this charter was put into place. Historical.
There was no 1997 amendment to this provision. This is the original provision from 1946. So that, or whatever.
All right, so I don't think we have any changes to that right now, so you don't have any work there. Yes, yay.
Yay.
Let's go now to our old business, which is chapter 17. And, thank you for putting that out. We have a proposed.
I will caveat this with, I was hoping that the recording, nothing but that it would work. It did not. So I had to go exclusively over my handwritten notes. So some of it was, I know we talked about the intellectual freedom. So I kind of just, obviously we're not married to this. I just wanted to get some words on the page. So hopefully I encapsulated most of it, but I may not.
just from my perspective, I thought you did a great job. But let me start with 17.1. I never saw that they wanted 7. We asked to have you do 7. I followed up with Kevin today and he said they want 5. The board did not want to change it. So we can go back to 5, just the original language up there so that we don't, aside from adding the East Lansing Library Board of Trustees in the first line in the original, the rest could stay the same. So that's the only thing I have for sure. And, do you want the mission statement in there? Does everybody feel that way? And again, I'm gonna say this just because I'm here and I'm talking first. If they change the mission statement, we gotta change the charter and that's something that they review and I don't know that we want.
I did, right, no, I put in there, I said mission statement, so I didn't know, I was like, I'll find it, because I think we talked about like the American, it was American Association of Libraries or something, so but again, this was just, I didn't have the recording, so I was like, I'm gonna just put it in here, and then if we don't like it, obviously I can take it out. So I want that in there?
No,
Okay,
I would just, because people change their mission statements all the time.
right.
And it's very standard.
Yeah.
It's not like something really special.
We did discuss as a backstop to making clearly our stance as a city to freedom of information.
I think that's in the end of this, where she put into the intellectual freedom.
Oh,
I think the collection development,
that's what we're talking about.
no.
Oh,
Yeah.
No, I thought that.
I was like, why don't
Really
know what
good.
I wanted to say, so we'll just put this, yeah. Well, actually, so I got that largely from your current library, they have their own
Yeah.
statement or policy or however they say it, so I very much connect that.
And I want them to look at this too. See what the library trustees, the director feel about the modifications.
Diane, you did need feedback, but on this, I'm assuming he's very.
No, he didn't say anything about this.
Some of the stuff, okay.
We were just talking about who heard from Mr. Hollister.
Yeah, and I
We were
think
all
he
trying to
should be.
figure this out.
That's what I discussed.
But my thought is that we should, for today, hold this until the next meeting and run it by the Board of Trustees of the library, especially for 17.6. Make sure it's consistent with what they think it should read. I do think I have a couple of minor edits to the end of 17.6. I think the second to last sentence should say the selection of library materials shall be made on the patron's right to read, etc., as opposed to is made. And that this last sentence should read, the East Lansing Public Library shall hold censorship be a purely individual matter. And
Is that one again? East Lansing Public Library.
shall hold censorship to be a purely individual matter. And shall declare, I don't know if that works in that context. But I think it should be more, Pam, what was the word you just used? Okay, it's gone, but it should be more, forceful as opposed to just saying what it is. It should be a
You're
mandate.
giving a directive.
Yes, it should be a directive or a mandate as opposed to.
So you're saying shall hold, and what was the, shall hold and,
So in the second to last sentence, it said shall be made, and in the last sentence, shall hold censorship to be a purely individual matter, and shall declare that while anyone is free, et cetera.
Yeah, all the words should be a directive.
Yeah, sure.
okay. I think we should edit any of our proposed changes before it goes to the library board, just so that they see what we have. So let's go back to the 17.2, because 17.1 would stay the same, except that we would call it the East Lansing Library Board of Trustees. And do we want, I know the chapter heading isn't part of the I want to say constitution, but the charter isn't part of the charter. Do we want to have the heading say East Lansing Public Library, or do we want to just say city library? And again, I'm trying to keep us away from not having ever specifically CATA, in conflict with that this is related to the East Lansing Public Library. And the charter would have to be changed should we ever do some CATA stuff too. So,
They don't just change their name, they just join.
so can we change the heading to East Lansing Public Library? Is this?
Given chapter 20, given chapter 20, can we just do that? Or does it need to go through a vote? Chapter 20 says that the headings don't mean anything, they're just words. If they don't have, so.
But we're making.
I think
other
that's
changes.
just to use as a guide in interpretation, but I think if you're gonna
You're gonna
make it, if you're gonna put this on the ballot anyway, why not?
Yeah, there's other
Lansing Public
changes.
Library.
But if you look at 17.1, call out the East Lansing Library Board, then we already got the name. Even though the heading is what it is.
Right.
The body says that'll stand. Right?
Yeah.
You should insert both. Under 17.
See that the first line is. The library board.
That line 4 as East Lansing City Library,
So some consistency.
public.
See, that's where we're going into this. And, when Verge Bernero was mayor, he wanted to combine the two cities. And then again, we're going to be a city library. That's why I would just always keep saying East Lansing Public Library.
Yeah.
That was his mission. Okay, does that make sense? All right, so then 17.2. That's when Kevin come back and said, the president, vice president shall appoint. And I don't, is appoint, is that the right word? Because
They elect.
they elect.
Or select.
Yes, they do elect. So instead of appoint, so.
Is that through their own processes that they elect?
Yeah.
Because appoint just means that they have to pick someone. If we change it to elect, that means we're requiring them to elect someone. So I think appoint gives the board of trustees more discretion in how they want to do it. Because you can choose to appoint someone by electing them, or you can choose to appoint them by just picking someone.
That's why we have four lawyers.
So are we back, we want to appoint then?
Points, yeah.
Okay.
How about select?
I think those are the same
For
thing.
city council in 4.4, we use the word elect. We're elect the mayor and the mayor pro tem.
But don't you vote?
Yeah.
It's a vote of the council.
Yeah.
So
Yeah,
this would be a
but
vote.
we
of
don't
the
know
board.
from we don't know from library votes, maybe they're just like Shirley still.
Well,
president.
if you don't, you're sending it to them, they'll send it back.
Yeah,
Do that.
They do elect, they do elect. And the beauty of the 5-year terms is it rotates. And so 1 year you're the president, vice president, and secretary. The two people have a little break from those duties, but it has to be elected that way each time in that first meeting. So they do that. And should someone not be on the board or resign and stuff, then that kind of changes everything too. So it is elected. And I think you want them to elect that because of the powers that they have, hiring and firing. Sort of like city council has their powers to hire him. All right, and then the last sentence, we definitely want that out. Well, because it goes into later.
I can't imagine anyone would vote for that, getting rid of an audit of the board. So you gotta keep that into consideration.
I just said, I
moved it under the budget.
Yeah, it's in a different section, because I think we wanted it under budget.
Okay,
Yeah, I
that's
put it at the very end of the
We'll just have to
budget.
make sure that people understand.
Yeah.
Okay, and then 17.3. Do you want to say that East Lansing, do you want to be again consistent here with the East Lansing Library, Public Library Board of Trustees? You want to use that system through the whole thing?
The same thing at the beginning of 17.2 to go back to it's the members of the East Lansing ELPL board in that first sentence.
even in 17, where it's the library.
Yeah.
So,
We just saw that earlier.
yeah.
As long as the acronyms right there. biggest. And then so you have in the middle of 17.3, you have that city library thing too. It's called city library in the middle. Okay. And then the last thing is also Kevin, the board shall, and our positive directive would also hire a library director. The library director serves at the discretion. Employees of the library serve at the discretion of the library director.
Do we need the word also in there?
So
It just,
shall hire, this is the last sentence of 17.3. If you're ready.
I know, I'm in that color, I'm struggling here.
Okay. The third line from the bottom, right where your pen is right now. Also doesn't need to be in there.
No, shall I?
And that's, now that we have unionized employees.
That's just what I was going to too. So the point where he'll serve at the library director's discretion, unless, covered by a collective bargaining.
Is there a word that would not serve as the discretion, but will be led by or?
wait, are you talking about the worries about the library director being?
No, we're saying they're union, no, we're saying the staff is unionized now, so can we say that they're at the discretion says hire and fire?
Well, you could also say the library director, the employees will be responsible for all library.
Yeah, that's, yeah, so
You could just say the library director shall oversee the employees of the library.
that's,
Oh,
yeah,
I'm
that's.
sorry, I was a sentence ahead
Because
of
that discretion.
that. You're talking about the library.
Now, the trustees can fire
Right.
and hire.
Right,
Director,
director,
but the
that's what I
director's
thought.
gonna be buddy.
Okay, yeah.
That's direction.
Can you look up when their next meeting is, because you'll do that faster than I can. I can do 3 multitasking. And so we'll know, we'll see this before we send it to them. Because I think we want to see it before we ask them to respond to it.
Looks like they don't meet till the 28th.
So I knew some of them find it faster than. Okay, so
When
we'll
would you
have
like it by?
the next meeting. We'll meet before. they
Okay,
meet.
okay.
That was my. Okay, library budgets. I did like that language in accordance with the budget schedule approved by council, because then the library director would tell the library board, I have to have a budget in. They in my experience, the library director does a preliminary and presents it to the board. And then it goes to council when they have their discussion. So that flows very nicely with what is the order of how it should be done. And there are careful estimates in detail. And then that's where the audit comes in at the end. And you added and available through its millage.
Yeah, I wasn't sure. We had millage language, but again, I don't know where we were, how you wanted that to sound. I wanted that in there so we were discussing it, because I know that was discussed at the last meeting, but I'm not sure how you wanted that to look.
So Mark, you can sort of address this too. On the library, because the millage is a certain dollar amount, they know what it is when it's 10, and they build their budget just to match that millage. But there's been times like when we had the extra money that was coming in from the government's ARPA funds. The city was telling how much of the ARPA funds could go to the library. So I think this way you have worded it this way tells you that the city has some kind of authority to give some money in the budget to the library. But you're not going to give them less than the millage. It's just if there's other money available and you want to do something like pay for the parking lot for them instead of having it come out of millage money, you can do that.
Yes. Okay.
And that language looks that way.
I read this as indicating that the library has a responsibility, library administration has a responsibility to present its budget to the city. If the city council decided there was, too much slush in there and, they were going for things that maybe they shouldn't, we could reduce their budget for that year. We can't reduce the 2 mils worth of money that is attributed to the library. If we were to reduce their budget that they submitted, that money would go into their rainy day fund, so the reality is, and as you know, there was a point in time after the millage was passed that the rainy day fund started to grow pretty big because the library didn't quite need that amount of money in order to operate. It's been renewed. It's money that has to be spent in relation to the budget. That's the only control that city council has. As far as ARPA funds go, those came to the city and then were sort of doled out to programs, including the library in some respect. So yeah, that was a city council decision.
And so this language covers both ways.
Absolutely. I think it's sufficient is what I would say. And even the idea of the audit, the audit is a very important power to have. And it also, at some point, we audit every department at some point to make sure that money is being spent in a way that is appropriate for the citizens.
Yes, Joe. On that, about the audit, it says I can't read mine because I didn't have the yellow ink, but all accounts of the board, I think, should be in the library, not in the board. So I think that should be changed.
And their millage is 997 mils, but just under 1 over. As well as approved by voters in 2020.
I think we have judgments about the British way too. 17.4.
Think you have what?
We have judgments about the British way, and judgment may seem justifiable.
We're just being diverse.
Is it the same as at least consistent? Oh, no, it's not.
No, it's
consistent.
not
Yeah,
consistent.
there's the
Yeah.
one without an E above it. Okay, so we like it with no E.
No,
Yeah, no, we,
Okay.
See, I tried to always spell it both ways, all the way through everything.
I can edit other people's writing really well. I can't edit my own.
Well, that's it, right? Because
Yeah.
you see it, you see it, you see it.
All right. Took me a while to understand what you were saying, and so now I got it. Okay, 17.5, the library receipts to the chief financial officer. So I have an edit on that. The last sentence, the receipt shall be maintained in the records of the library board and available to city council, because they are not at their next meeting looking at the receipts of the library from the previous weekly. deposits.
Okay.
Just, it's available to city council.
I don't think I've ever seen one.
I know. That's why I knew when I used to pass this chapter out to the library board of trustee candidates, I used to think, oh my gosh, this has got to go, because nobody's sending something to council to look at
And
it.
we say shall be made available to city council, like it's there if they want to look at it.
That's what I was saying. And made available or available, because if you're making it available, are you giving it to them, or are you just saying, if it's available, they have to go look
Yeah, is it
for it?
reported in their meeting? Would it be in a meeting packet from the library?
The library gets the report every month.
Right, and so if the council wants to see it, they could go to the
Right, and
library's
it's-
packet.
yes, it's on
here. So that's, it's available.
Yes, yeah, versus sending to them.
Why would, my question would be, why would that, this seems pointless.
Yeah, that's.
So the receipt shall be maintained in the records of the library board, period. And it's available if anybody needs to take a look at it, which would usually be the treasurer or the CFO.
But-
It wouldn't be us.
But I'd like to see it publicly available in the meeting
It
agenda.
would be,
Yeah, that's, so it's, so,
but
but
it's foilable, so.
just wanted a meeting packet, then I can just go look at that meeting packet. I need to FOIA. It's just, part of the,
They would reject the FOIA according to our city clerk because it's available.
yeah.
Right. So do we just, the receipt shall be maintained in the records of the library, or in the records
Library period.
of the library period, right, the library period.
And no, the
Nothing
city,
after
okay.
that. Nothing after that. Okay, and then 17.6. Attorney Foreman already gave us some really strong language in there. Anyone else have anything with this? Okay,
Clark, did we, because we're cutting the mission statement from the top, should we cut the mission statement here too? In the second sentence?
Establish a framework, is that what you mean?
Yeah, it's just establish a framework for the development and growth of library collections in support of the library's mission, period. For the same reason we're cutting the statement from the top of the,
And we don't want to have
Chapter.
to amend charter.
You could say library
Or we-
purpose and mission.
or we could just get rid of the quotes there and make that, you know, their mission without owning it.
And I'd really like to see them look at that too and see what, I think
It's
it's a line.
Yeah.
But they should be writing this.
That's what their mission still is without saying this, we're quoting from something.
do you like that, everybody?
Yes.
Yeah, okay.
Just get rid of the quotes. Okay.
That's chapter 17. And now we're on to 4.2, continued discussion on chapter 16. Go back one, and this is on our municipal utilities. There was, in our 117-page packet, there was a lot of information about our utilities, other places. And did we want to do any changes to what was in here? Does anyone, after reading all that, think that something else should be changed in here? Mark, do you see any issues with this in relation to the things that we've been dealing with?
You mean as opposed to the ordinance itself? I mean, the ordinance. No, you know, this is pretty standard stuff. You know, we have, our utility is the sewer and water. There was a point in time around, say, 2000, when we had authority to establish our own electric utility, that we talked about doing that, which would be permitted under this as well. And the same general rules would have applied there in terms of rates, utility charges and things like that. So I'm not aware of anything that needs to be changed here. And we did make changes in 97, looks like we not exactly sure what we did. Any longer. It might have been it could have been something that as simple as capitalizing city. I just don't know what we did in 97, but we made a change to each one of these sections. That might be worth looking at.
Let's see.
When you guys discussed this, did you discuss this previously? Diane?
We wanted to make sure that when we talked about this, that everything was, there was nothing with outside. And we talked a lot about really more ordinances, like what do you do with people turning off water and stuff, and then a lot of that information was then provided to us so that we didn't, it's clear that they were dealing with that already.
We are limited, we make reference here to the 1939 PA 178, which governs deal with enforcement, failure to pay, like that. We're governed by a state statute.
All right, so there's no changes to this at this point in time. I'll go back and look at that was that long document. I usually have that ready, but I'm sorry. Because, to see why those 5 changes were, but I'll do that during comments at the next meeting, unless there was some significant changes.
I didn't read all that, it was too much, but I am kind of got this cell tower situation stuck in my craw, and I'm I'm looking at the ordinances, so East Lansing did pass a cell tower ordinance in 2020. Now, my understanding is that's all been overridden by the state law that says we can't do nothing about nothing.
My memory is, I was not council at the time, but my memory is the council passed it, then a state statute was passed shortly thereafter that eliminated.
Null and void.
Ours was different. Ours was different and unenforceable. I'm not sure whether that one's still on the books.
It is, I just wasn't new to know that one is. Oh, the state.
Okay. All right, so now then we'll leave that as is and we'll go to 4.3, which is our chapter 8. Now, Jeff, we have two things that were handed out, and fairness, if you wanted, the people want to take a moment and read these before we start discussing them. We're at 8:09, so we have, a little less than an hour since they kind of came out, and one is less, Jill's is less detailed, but Jeff put a lot of changes into the one that we saw before. So why don't we take a look at that? Just take a few minutes.
Whose version is this one? That's yours?
That's Jill's, is this me?
Yes.
section.
That of us doing this.
Oh, yes.
That was my thought on that. Yes. Recommended change.
Yeah.
One of what I said is that they just maybe has to affect us not wishing to.
Okay, yeah.
Please don't love today. Or state. I think it's, then we don't require it. Oh. So it's this.
Yes, that's what Jason.
I don't think about it.
Showing me.
Do you know what the expression is?
It's gorgeous. Proof.
We've never had this to work too longer, and it sounds like everybody has read this. We were just looking at, April 3rd was when we had the FOIA policy as part of our packet. Those of you that want to look at that. So I'm just gonna open it up first. What are your feelings about, these chapter 8 proposals? So let's just start with that. Do we want to work through each one, or do we want to just talk in general about what we really want in the chapter, what we want in this?
Could I ask a question? Is, strikes me, why isn't this part of the general municipal powers section 2 that is already in here? Was there just a feeling that because we had an empty chapter 8 that wanted to stick something in there instead of renumbering the other chapters, or?
Yeah, so we had
This-
this,
this
we had
would be
the
a general
discussion.
Municipal power, and we already have a section.
Okay, so we had this discussion about putting chapter 8 originally because nothing there was there. And my feeling, and I've kind of asked the city attorney, is do you keep chapter 8 with a little caveat and don't put another thing in there, because historically now you know what happened with our municipal thing. And then we talked about it last time, just should this be in the preamble, because it was very important about transparency. Should we talk about this right up front? And we never talked about putting it in the second chapter, which is early on. And it's, he makes a good, a valid point about it being municipal responsibility to do this. So where we put it at some point in time, we can come to decide on that. But now it's, what's the group's feeling about these drafts? Sure. Sure.
I thought the other one was confusing, is that there's different kinds of records, and we were calling them the same thing. There's the board and commission stuff, I should be on a different path, in my opinion. There's financial stuff, and then there's the FOIA stuff. And that's what I tried to do, was spell the three different kinds out. Which wasn't as clear, I think, in the original one. So that was what I started to do, which just what led to this.
which I loved you. So I am a huge fan of Jill's, particularly 1 through 3, as being for Joan Q. Public and the things that you don't have to FOIA. FOIA is, to me, like, that's a special situation. Most everything I'm gonna wanna see is gonna be a Unicode, or it's gonna be a minutes for a meeting, or an agenda packet, or whatever. So I love that that's up in front, and that's what I'm seeing as a citizen, just, a declaration of where the stuff is just gonna be available. I might add a low-cost manner and in accordance with the state of Michigan Freedom Law. So most of the stuff is a low-cost manner because it's just the agenda packets and you can click on it for free and go to Unicode or the library. Then I think 8.4 maybe starts the FOIA area, which the lawyers discuss, or like that.
Yeah, and I agree with you, Pam. I like Jill's version. I tweaked some language and make it a little bit more directive in her draft, changing wills to shalls along the line. And there was a minor tweak that I had with where things would be not along with, but and at the public library. But I read the more detailed version. I think that there's some inconsistencies in it, which we can, try and work through. But this is really complicated. It reads more like it's very detailed, and it reads more like an ordinance to me about what should be done, and it will be, and how the city goes about enforcing what the transparency goals are of the city. This sounds more like, Jill's version sounds more like the charter, the here are what we want to do. This draft that I think Jeff gave, while I don't disagree with much of what's in here, it just seems to me like it's so highly detailed that it's a way to execute the transparency that we're trying to achieve in Jill's version.
I third that, and I think this is a lot more readable, and I like that it's segmented out so that, they can go to whether they're looking for FOIA guidance or financial reports, et cetera. And I agree with Attorney Foreman that under 8.4, the last sentence that reads the city council may wish to, we just took out wish to. So the city council may provide guidance. And I also think that we might consider bulleting under 8.4, each of those three. Making those A, B, C.
Yeah,
Or 1.2 or 0.3.
Yeah, point.
Like that would.
I think it'd be,
Convention.
I think it'd be ABC to match with.
Yeah.
Other, yeah.
And on a non-related to the charter, whatever happened to the FOIA dashboard? That was up and then we chose to pull it down.
We're looking, well. So we're looking to turn it back on, so we use just FOIA. And so we're looking into, I believe there's a public facing version of that.
Sure.
So maybe Gordon's reaching out to Just FOIA to find that out, so that we can turn that on and we can avoid the FOIAs that we get asking for all the FOIAs that have been filed, because it'll be there and you can just go look at them
Well, and
instead
also,
of getting the FOIA to provide all the FOIAs.
and the chair mentioned that as a council person, she wasn't necessarily aware of what kind of FOIA activity was going on in that. I thought maybe the FOIA report goes in, the consent agenda is included, but if there's a dashboard and then anyone can look at it, they can see if things are sitting around or not.
Yeah, we're looking to reactivate.
And that seems like that would really address the concern that they're being negligently not handled. So everybody could see if something's not being moved through the process.
Or if you've already provided it to
Yeah,
someone.
yeah, too. Right, but I'm trying to address the concern that they were, that requests were being not addressed in a timely manner. And so then you could see in the dashboard, hey, then you say, this one is not being, you'd be able, it would just be public.
So, okay, so we're sort of hearing about this, and if we went that direction to keep it simple, then, what you have worked on, Jeff, but also we could take a look at it as, a possible push to, when we present the charter changes, to suggest this is an ordinance, because we were looking at the ordinance that was here, and it's not near as detailed as what yours is, in terms of, breaking out each section of things. So tell me,
So I want to turn, seems like there's support for what you'll get out here, it's the neighbors chill thing, but when I read what you have here, Jill, this is just going to, doesn't go any farther to actually increase transparency, so, which was the whole point of trying to put something in the charter that would go beyond what state law is for you, which is the minimum.
Where's the beyond way?
It's a lot of this stuff is beyond what in the draft. Jill's draft, it says, in accordance with state, in the very first transparency policy, in accordance with state of Michigan's freedom.
Where,
What you reiterate in this draft would just be that the city is going to follow what.
well, FOIA says you have to have a coordinator. I mean, what are we seeing in here that goes above and beyond FOIA?
Some of these things, 8.2, 8.1, 8.3.
Oh, wait, so
8.4,
coordinator
8.5.
and not merely process request, whichever C.
Start with 8.1, transparency policy. Timely, without charge, and that I got from two of you, including I think Dr. Johnson suggested that be changed, because we had free and immediate. So that was the city charge, but they can charge them. Yeah, they don't have to, as we heard, they can, don't.
Right, we do have some
It's
choice.
not that inconsistent, but that's one of the lead inconsistencies in your draft, Jeff. You say without charge in 8.1, and then in 8.4, you say cost charge to the public. And so when do you charge, when do you not charge? I think that this needs work.
8.4's first sentence says, in general, the public should give access to public records and information without charge.
But
Right.
in 8.1, you say it shall be given without charge. So it seems to me that that is an internal inconsistency.
So the word general is the thing that's really different.
Well, I think that there are circumstances under which we have most of, unless I read the room wrong, and that's entirely possible. But I thought that we understood that there are certain, well, most FOIA requests are responded to without charge, that we can't make that as a blanket rule, that there are circumstances under which substantial requests for information will need to be charged.
Hours worked.
Yeah, the hours worked of staff and the amount of the volume of information may justify charging the under
FOIA.
under FOIA, you're allowed to do that. And I don't see anything that would justify, especially given East Lansing's present fiscal situation, to detail a staff member to go run down some information and not charge whoever wants that for it if it's a particularly large request. I'm not even going to describe it as onerous. It doesn't have to be onerous. But I think that that's a consideration we need. That does not mean that the city's not being transparent. It just means that the city's being practical about within the parameters of state law and the city's staffing and fiscal restrictions, that there are times when charging somebody is necessary.
Right, so I got to respond to that, because 8.1 says for economic administration, we do that. 8.4, section E, it requires a substantial expenditure of funds. You can do that. There's nothing inconsistent where they cannot choose to justify charging anybody.
is without charge to the maximum extent of the
Yeah,
system.
and we heard from the clerk that for most of the circumstances,
Right.
people don't get charged. So when someone comes, she said, if someone comes in with a big request, that is actually.
I think the way this is worded, I think the wording's confusing and you're gonna get a lot of people that may end up getting charged, even if it's just a copying fee. It's they're gonna come in and look at this and say, it says you have to give it to me without charge. It says all of this stuff is free.
I think it would say, but it doesn't say free, so remove the word free. Strike out such a, the second point, what I've heard you say, Lynn, at multiple meetings now is you want this to be, what is FOIA? It's like FOIA,
Okay, we're
FOIA is the standard, right? That's what you, is that correct, the way you sort of said?
FOIA is the law.
FOIA is the law, right, but FOIA is the floor. The city can go beyond FOIA in providing information. So this is like where the fork in the road comes.
On that point, I think it's unfair to say that Jill's version doesn't go beyond FOIA at all. Jill's version requires,
We call it something.
No, be proud.
You have no emotional attachment.
I don't need Jill's. Well, when we started this, even Mark said something along this line, when we had that original draft, we just reiterated that we're following FOIA.
I mean,
Don't
so
want
just
to have things that based.
to finish my thought, I think that there was a recommendation that at 8.1, that it be amended to say will be provided in a timely, low cost manner and in accordance with FOIA. But in 8.4, it goes beyond FOIA. It says that request will be provided, or I think obviously responded to, as soon as possible at the lowest possible cost. That goes beyond FOIA. It says that extension shall be used only when absolutely necessary. That goes beyond FOIA. It requires that it be reviewed prior to distribution by a knowledgeable city administrator to ensure the documents are responsive. I'm not 100% sure, I'm not an expert, but I believe that goes beyond FOIA too. So I think, I understand that, Jeff, that you want a much more detailed articulation of what the city is required to do in the charter, but I also think we should be fair to what Jill prepared here, which I think does much more than the floor of FOIA.
Yeah, my concern is that I appreciate Mark Rebner's input here, and I appreciate Jeff and your lawyerliness and the critical nature of FOIA. I feel very similar to our previous public comment. These are meant to address a lack of responsiveness from the city or the city's operations, our city operations, not them not liking our city operations. But not the word, like, so they're addressing, like, we wish this was faster, or we, things that we want it to be nicer, or, the things that I'm not sure are clearly articulated in terms of this is the request. It's, yeah.
Can I ask you a question? Okay, let's just say that Jeff's version is more appropriate as an ordinance. We don't currently have this type of detailed ordinance on the books. We had a resolution passed by the council that was relatively detailed about the FOIA process that was replaced with an administrative order issued by the city manager. So my question to the city attorney is, what is the appropriate way for us to handle the detail that might be necessary that goes beyond? And I'm not advocating that we change chapter 8 to say Jill's version, but Jill's version of what we should do. And I don't know if you can answer that or not, but.
I mean, I'll look into it. Yeah, I mean, I don't want to, it is to the, I mean, so if I'm understanding, do we want, is it the idea, we definitely want something in here. We want to have some sort of charter provision and as to how detailed it should be, correct? And then do we want to have, is there this, I mean, well, I guess you don't really have quote unquote, but is there a discussion as to whether we want to put perhaps Jeff's version as an ordinance? Is that, and then is that appropriate,
Ordinance versus administrative right versus
a resolution, what is the way that we commit as a city to do something? And Mr. Bellman's next, but
I just want, I don't want to be, this is not Jeff's version.
No, I.
You actually put this together, but now you're like, I like Jill's version. But
I do. The more, it's not bad. No, the more detailed,
Yeah,
I guess,
clear.
yeah.
I don't like
This
this,
was not
I don't like for you.
we, others came from other people, including comments from people here, so I just prefer not be like Jill's version.
okay, okay. Proposed, okay, let's just call Jill's version
B.
and,
Right?
and B, okay, so A, that way we. Okay, and Mr. Bellman's next and then I next.
So the only thing I was gonna add is it'd be nice when we're talking transparency, if we could start identifying documents. Because you say all information is too large or encompassing and then gets into uncertainty. So one thing I've started looking at is any contract the city enters into should be listed on our website. Any action of council is already there.
Contracts in the agenda for the packet for the.
Some over a certain dollar amount goes, but under a dollar amount, I sign, but
Yeah.
they all should be
Yeah,
in
available.
an area where someone can go
No
look
for
at
you either.
contracts that we've entered into each fiscal year. Likewise, if we can get, our financial system in a position where we can show every check we cut, unless they're exempt by some states. Give you an example is, victims repayments. I don't know if we issue them on behalf of the court. Those aren't allowed to be public.
Right,
So,
specifically.
but, there are communities out there that have what they call open checkbook. So you can go see how we're spending money. And then you can come to council and complain about how we're spending money.
Right, and to me, that is the kind of thing that council will dictate and also say what's gonna be in the agenda packet. Maybe, like if this is included in the agenda packet, then it's available.
Well, the section of the agenda that is the city manager's report, that basically that's an oral report. But it could, if the city manager had signed, say, 6 contracts for under $20,000, which is within his authority, there could be, you could click on that and maybe look at those. I mean, it isn't necessary for him to make an oral presentation with regard to them, but
No,
that
what
would be
you're
okay.
provided that under policy now, every quarter. The contract I signed under 20,000.
Yeah, and if that's in the agenda packet, then it's public. It doesn't need to be FOIA.
Does it make sense then when, our city attorney comes back with where the best place to do this is? Does it make sense in proposal B to refer to that there is something, so it mandates a charter that there is, whether it's an executive order or an ordinance that describes the process of doing this. Because things might change with this, with the states.
I think it would be beneficial to list categories of documents that we're trying to make available. Instead of just saying all information, because again,
And that 8.1 is such a broad statement, just, you said in possession of, under the control of the city to the maximum extent consistent with necessary protection of personal privacy, economic administration restrictions. So I'm trying to think, when I read that, I'm thinking, what kinds of things do we have going on that you wouldn't want out there? Let's just say there's a property that these people are thinking of buying, and they're thinking of putting something on there, and they bring these documents to the planning department, and they say, here, we don't have control of this property yet, but we're thinking if we went this way, does it meet our city comp plan? What kinds of things do you see? If that document under here is sitting in the planning department, that puts the people that don't even have the option on the property yet, and
That's already available. The writing the city has. So I get, you have a good point, though. All information sounds really broad. I think that can be reworded to public record, all public records. This was drafted to be consistent with FOIA, and this is kind of, a few things I keep hearing is that people think like, oh, this or that, and it's like, FOIA already does a lot. Even like, Lynn's saying, well, things can be onerous or whatever, like, we heard from the clerk, like, you know what they get, they're not usually onerous. You know, people can request for all sorts of stuff, and you have to give it. That's usually how it works. Just to your point, that was the intent, so I think all information could be read, I can see that can be changed. But what the example you just gave, is already something someone would go for. Unless it falls within one of the FOIA exemptions.
So, well, the other thing would be too, if it's formally, because I know I'm with like building board of appeals, so if it's formally given to the city, because the rule is
That's what I was saying.
Yeah, it's a
It's
complete
an
adding in possession.
informal, when we're having these discussions with the planning
Well, if
department.
it's informal, the city doesn't have.
Right, and then in which case it couldn't be
If
FOIA.
someone comes in and just talks to you and shows you something, doesn't give it to you, whatever, your possession, like emails to the city, whatever, the city doesn't have it.
That you're in possession is the formal thing.
That's why I try to use that word, because that's against. This would try to track state law, right? That was a big goal of that, and it's not to be critical, Jill stepped out, it's not to be critical, which is better here, but it's a lot of stuff. What proposal B is not, it doesn't track FOIA language. Some said you definitely need, some language.
I mean, I think the city attorneys can punch up proposal B to make it consistent with state law. I think it's all, but also I think the benefit of proposal B is that it reads plain, and not technically.
Was that Jill?
So Jill's just speak.
Yes, Jill is speaking. Sorry, I'm trying to follow this.
Trying to avoid.
I think it reads plainly, and which is one of the goals we were going for, especially in transparency provision of the charter, where that's the one that we imagine citizens are going to be looking at to see where they can find them. I think that's a benefit of proposal B.
And I think with both of them, I like the concept of proposal A. I mean, truly it doesn't give anything more because it says with the restrictions of law. So if you're thinking of, well, your example, they wouldn't have it, say like medical information or anything that was like crime victim related. That's going to be restricted by law in of itself, so that really does encapsulate that. So if I worked on proposal B, I would, if the idea is we want it to be all, however I'll word that, but that absolutely has to have the restrictions imposed by the law. That's going to be the protections that we need. And that would cover everything then. Yeah, I'm not.
I guess I just look at, it's nice to put it in there. But if there's an out, then it's gonna be confusing.
Yep.
And so that's why I say, if we identify public documents that will in fact be made available, would in essence be beneficial to the reader. But if you say you're gonna make available all this information, except that is exempt under law, then you're not probably hitting some of the interests that our residents may have.
Maybe if they got really like the committees and the council say, please include this in our packet. This is information. If someone's flying something, maybe that starts to come in front of committees. So it becomes,
But I guess I disagree with that. I don't think you need to be very detailed in item B's version of what transparency would be. If you said it is the policy of the city that all public records will be provided in a timely, low-cost manner in accordance with the state of Michigan's Freedom of Information Act, you have adopted the public record definition in the FOIA, which is what guides us in everything that we do anyway. So the only thing that I think is missing from there, personally, is how we are going to set up the system within the city as to, so if it said in any resolution passed by the council or any administrative order passed by the city manager or enacted by the city manager or an ordinance set out and adopted by the city council, then we give room for this greater detail that, for instance, B,
A.
A proposal So
Is it,
I think that's sufficient in terms of a charter provision, but not necessarily in terms of the detail that we would need to actually implement what we have here.
would it be worthwhile to add, I got very loud, to add, council shall adopt a policy supporting
I
this,
think that's a great idea.
supporting this charter provision within 6 months of the passage of, or whatever reasonable amount of time would be back on that conversation.
Yeah, I don't think you need to put a time frame in other than the mandate
That they shall.
that they add.
Well, I'm just gonna go to 8.2, just on B. And, on the third line, and it says, all current and historical records of any city council, board, or commission included, will be available on the city's website. We have not digitized all historical records here and or. And so we have to define until, the historical and all current records will be, all historical records when digitized will be available somewhere, I'm putting it that way because we have too much in the past that's not there.
Yeah, I take all out of there. I would just strike that, it just say current and available historical records to the council, because they become more available, they would have to be, included.
But you can still get them, you just have to get a hard.
Right.
So what if we just said on the website and or at City Hall along with these letters of public library? So if they're not digitized, you can still go to City Hall and get them.
So if we want to go to get the planning commission from 1993,
It's not gonna-
it's down in the basement of, Hannah here. Someone's gonna have to manually pull them out. Yeah,
They're in
Yeah.
boxes.
and, I just don't know that, I don't know, again, when you're gonna have money to
That's gonna be
digitize
free.
and stuff like that. And so I think you have to, if you're putting this in a charter, you have to have some caveat for these things because it's very different. And I know that we have the year that these things went online, all the meetings went online and all that stuff, but, things before that, I mean, I just watched, nerdily, I watched the city council meeting and a planning commission meeting. They asked a question of the planning department about some past thing. And I have the file in my file cabinet because it was an important thing to me, but they didn't know, they couldn't answer the questions because the records weren't there.
But they're in the basement, they said, go get them.
They didn't go get them when they presented it because they just didn't, because it wasn't FOIA. It was just part of a planning, the next step in this project. And, they're asking questions, well, why this, why that? And a whole new planning staff, a whole new, group of people, no records that are digitized. So we can't put something in here and say everything's gonna be available because it isn't.
It's just a question of digging it out of the basement.
It's when it's digitized. And I don't know where
No,
you're
it's
at
when
with
it's
this.
how long it's gonna take to get it. It's not available, but if you do have it in the basement, it is available. So if we had a FOIA for it, we'd have to produce it because we do have it,
We know
right?
it's there.
And that would take a lot of time, Jeff, and they would have many extensions.
I'm not the one who said it should be digitized. My version A, not yours. No, version A does not say that. You can charge for that, you gotta go pay for.
Go ahead.
I just have a question if anyone knows, like regarding historical records, is there any sort of like retention schedule or like?
Yeah, we found
How long
this text.
Okay, so. Like
Yeah.
we,
But our retention schedule is forever.
okay.
As far as I know, we don't destroy anything. We do not have an approved retention schedule that is required.
Okay, so that's cheap.
They dump anything, that's why
We got
there are boxes of stuff in the basement.
Okay.
Can we ever go down there?
You're welcome to go
I
down.
don't think I want to.
When we were redoing the building, we thought, hey, what use can we make of the basement? So we had all kinds of ideas. And we decided to store boxes down there, so that's it.
But it was the lab.
All right, so somehow this has to be worked so that,
I'll send
I
it
mean,
out.
again, if you have official records of boards and commissions, so let me just, you want access to the Arts Commission of 1990. Is that,
That's in a box too.
sure, not like, those are all manual. I mean, some of these things weren't even typed there, you know. And stuff.
So we should say on the city's website, Diane Gutierrez's house or.
Study folders. I won't tell you what they are. There's two folders that are important.
So I know we compare files because I also saved the files. I thought, this is really important. I'm gonna keep this.
Yeah.
So sometimes I can go back and pull stuff out of a file that is 20 years old.
I do a lot of digital archiving for the university. And so we do have it. Now, how long it's gonna take you to get it? Like, the only reason to save it is if it's available, if someone wants it. Now, is there gonna be a cost for that? Because it hasn't been digitized, it's gonna take 3 hours of staff time. That's a thing, but it is there. So I think the fact that we have the information, I mean, I don't think it's gonna be that common. And maybe if it's gonna cost somebody $50, that's not that important, but
And I'm assuming there's no plan or really desire to digitize.
they're
I thought
digitizing.
that was sort of their strategic priorities.
It's
Yeah.
something that'll get put on the back burner.
Now, because of the shift.
The library is interested in assisting with that. It's
So just that somehow you have to word that paragraph to know that.
It's not all digital.
It
Yeah,
always
it's
will
not-
all be on the website.
Yeah,
Mhm.
It's the.
I think, well, I liked the idea of, was it and or at City Hall?
Yeah.
That it captured, right,
Or I guess we should say Hannah.
okay.
No, that's.
Well, it's gonna be available at City Hall.
Yeah, but
We're
you're
not
not
gonna
gonna
be
be.
digging through the basement.
You're gonna have to request it, and you may have to
Okay.
deploy it because it isn't readily available digitally.
So you could easily say on the website or from the city. It doesn't
Yeah,
matter
yeah.
where it's at,
That's right. Yeah.
from the city.
You can go to City Hall looking for it or the library.
Yeah, it
Either
could be
of them
any
may
of
be able to
those.
tell you
It's
that.
from the city.
Be surprised if the library would be able to say, if there's a hard copy, you're going to have to do a FOIA request through the website. The FOIA website's lovely, right? We've got it quite explicit.
Right, I just don't want to be in a position where we're saying it will be available at City Hall, and then we have someone coming in here and saying that they're gonna steal this because it's in Hannah instead of City Hall.
You know the rule, they can always do.
That's the truth.
We
That's
digitize
Quiet, but
you
it's
say
true.
or from. That-
our digitized meetings end in, let's see, October 2nd, 2012.
That's
So
awesome.
go back.
Pretty darn good.
No, I think you can see.
I'm just looking at it right now. That's all that's on the website.
I thought it's granted.
That's Granicus. I'm looking at that right now.
Granicus was before I was here. It's when George, it's shortly after George Hannah's board, because he brought Granicus back from a meeting that he went, the Big Ten board, city managers. Just come out.
Yes, this, you can pull the agenda packet from January 10, 2012 on, but that's a different click here.
So it seems, go ahead.
I just wanted to say kudos to Jeff and to Jill for taking time to do this. And Pam, your help too. And I wrote a note down a few months ago when we first started talking about what will chapter 8 look like. And we said we needed a spirit of timeliness where feasible, but what would be important is the posture and the tone. And that the city would have something to go on with that and gave them the specificity, but just enough of the timeliness they need, and especially the tone. So you both have for some of that.
Thank you.
And
That's good. So let's just go back. Do we want it to be chapter 8? Let's kind of make this decision. Do we want it to be chapter 8? Do you want it in municipal powers, or do we want it in a preamble? Let's just get that off right away so that we know where we're gonna put this.
Shouldn't be in the preamble. You could say transparency in the preamble, say that anyway. You have the section on transparency, it should be a separate section.
I think it's a good vote on it.
Okay, so then do we want it under our municipal powers?
Right.
That's early on in this charter.
What else is in there?
But,
Powers of the city, exercise of powers,
I mean, it's
two
part,
point three.
part of this, like how front center do we want to say that in there? Transparency. If you go chapter, I should probably. Says something else, is that it's front and center to that. Maybe it's broken, you know.
I would suggest that I don't see, I get it that it's a power, but it's almost the opposite of a power, like the power to restrict the information. Not the power to make it public.
But that's exactly what the general municipal powers, the limitation as well as an expression. So 2.1 is powers of the city. 2.2 is exercise of those powers, and those are limitations on the exercise of the powers. And this would be however you title
So the
this.
city has no power to limit public record access except where specified by
Basically
the
says-
privacy and other laws.
I
And
think,
it sets forth the policy.
I think I agree with Jeff that it should be in some chapter, whether that's chapter 8 or new chapter 21. I think that highlights the importance of it, and as opposed to, kind of stashing it away in another chapter where things get broken up in a weird way. So that's my thoughts on it. That should be some chapter where.
And it's a will not, so we will do these things, we will not restrict information.
Sure, yeah. I would
You know,
say-
you do have the power to recommend a reorganization of the charter as well. So if you thought this should be at the front, it could be a new chapter 3, for instance, that is titled this, and then you would renumber things after that.
How would you explain that on a ballot?
How would you do that on the ballot?
Chapter 3 now, chapter 4 is 4.3,
You probably have a general provision that renumbered, and then that would be associated with any changes that you could make.
so you would just say the new chapter.
It also be chapter 0.
Well, but haven't we already made some global, a referral about globally changing? Pronouns and stuff we can do it within that same thing where, we recommend that, the chapters be renumbered to accommodate a new chapter. I think that's the easiest way.
And you could also eliminate the now vacant chapters and do that in an historical note in the final chapter of the charter.
Do that under miscellaneous.
All right.
Okay.
Yeah.
Well, I like that piece, because then it looks dumb just sitting there.
Yeah.
I'm less concerned with where it goes than whatever the final draft is, goes beyond FOIA. And you can legitimately say to people, city of East Lansing, we are at the forefront of local government transparency. We've accomplished something that puts us ahead of the pack. I don't think we have yet. That's what I'm saying. I want, the final draft should be something like, well, we definitely improved transparency within some reasonable bounds. It goes beyond the minimum listed law allows. I don't care what it looks like, as long as I can say, you know what, you really did that.
Okay, so why don't we leave it as, you're gonna rework B.
Right.
And you're going to look at A and see where certain things might address exactly what Jeff is talking about, where we're going beyond what words we can use in terms. We talked about the resolution or ordinance or administrative order or executive order. Want to do that too. Putting that in there, and then that's something that we'll discuss at the next meeting, that draft.
But the kind of, the base will be more B, and then pull maybe some. of
That's
it.
what I'm hearing from most of the.
With regard to B, then I have two more things that I'll just bring up. The FOIA coordinator historically anyway, has been appointed by council. That has been determined who that will be. And I think that has to be in 8.4 or 2.3D or whatever we end up numbering that. And then to Jeff's point, this last sentence of B that currently reads, the city council may wish to provide guidance on any instances where a cost would be waived or reduced, I think should be more direct. And I'm suggesting that you think about it anyway. Having it read, the city council may provide for instances where a cost should be waived or reduced, so that we have the opportunity to set up situations where we're just not going to charge any money.
And so it seems we're wrapping up. I make a request that we revive the misconduct in office conversation at the next meeting.
Was
I
that
think-
6.5?
No, that's not 6.5. I think that was something we kind of tabled back in October. That we kind of need to get back to before I'm getting close to the end of our year.
Oh, got that grace to put that on the school business. It's kind of.
Is there a specific chapter section?
Six. No, it's two, right? Oh, no, multiple lists. But there's a specific definition in 3.4.
But again, that doesn't apply to all the other instances that don't charge.
We'll run that after we have this discussion. And I think that's what we expected, that as we got through this, we would have to look back at some of the things. All right, so then, you're gonna have a draft for us on chapter 16, chapter 17 on the library. And after that, we'll send that to the Board of Trustees for their review. And then, chapter 8, I think if you draft something about renumbering, like you did with the gender neutrality ordinance, if you draft something addressing the order in the chapter, would be good. And then, chapter 8, for lack of a better word, we'll see B, and then we'll start to look at what we need to work on with that, to address just mission on that.
Yeah, I mean, I'm gonna beat a dead horse, but I think it'd be great if, like, Lansing State Journal ran articles like City East Lansing leading the way in local government transparency. Say, pat you on the back, Pam did a good job. Like, that's all I can accomplish.
And we know 6.5, we'll see with that after we get the transparency done. And then we're gonna do the misconduct in office as our role. And we talked about putting that the history in miscellaneous, since we have that 20 of chapter 8 and 9, and just an explanation of that. But I think is that the summary of where we're at with all of this.
Yeah, just to add that, there are also chapters where there were sections that were removed, even though we still make reference to like in 3, I think there's like 3 or 4 empty
Now, no longer.
provisions, so those should be compressed and renumbered too.
And then added to the comments.
But give me an example of one.
Blank ones.
I got to pull the charter back up.
And you got one other thing.
Oh, like on 5,
Yeah.
chapter 5, that's a bunch of things. Okay. That's an example.
Yeah, like these things.
13.13. There's nothing points.
Page.
Historically important.
Yeah, so as we captured the footnotes, that it was removed.
Right,
Yeah.
so maybe that's where we do this. So
Okay.
this one.
All right, did anybody else have anything to add on these for next meeting?
Do we still have one other item on the agenda about 6.5?
We can't really deal with until we deal with 8, and because 6.5, remember, is where we're providing everything here. That's related to transparency, because 6.5 is compilation, where copies of code and charter and all of this stuff is located. And if we got here, I can't see that will cover it.
I have a good question about that then. So do you want me to leave it off of next agenda or still put it?
No, I think because we have to go back to that language at some point in time, 6.5, yeah.
So put it on next one still?
Yeah, that's,
We don't lose track.
anything else?
Motion.
That's where you're starting point.
Thank you. Okay.
Motion to adjourn.
Four is supported by Veronica. Motion to adjourn by Foreman, seconded by Wilkerson Johnson. All those in favor, say aye. 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 Any opposed, same sign. Thanks.
Might get obvious.